Alex here with a legal nuts and bolts video on low risk, low reward. And this video, or the idea for this video, came to my attention when somebody asked me, why did I file an appeal over $50? There was a judge who denied a cost motion I filed for $50, and I appealed it and won the appeal. And somebody asked me, why would you appeal over such a low amount? And I told them that, let me go into this whole, the axis of reward and risk. There are things out there that are, a high risk and a low reward, which obviously you're not going to do because it's really risky and the reward is low. So the motivation behind it is just not there. Just don't do it. And there's obviously going to be things that are low risk, high reward. So yeah, there's like no risk to doing this. And if you do it, you're going to get a big reward. That's another no-brainer. People know to do that because there's not hardly any risk or no risk at all, and you're going to get something out of it. People also understand high risk, high reward. And people understand that because, yes, something is really risky and it could come at a price if you fail, but the reward is also high. So people understand that. People who, there's a lottery, custody cases. Those are cases where the risk is high, but the reward is also high. And so people go through with them. People don't seem to understand low risk, low reward situations. This just doesn't, it's something that just doesn't really cross a lot of people's mind. But there are situations out there where the reward of whatever it is you want to do is low, but the risk is also low. So even though you're not going to get a whole lot out of something, you're pretty much guaranteed, if you put a little bit of effort into it, to get it. And that's the situation that was before me. I had a low reward situation. It was just 50 bucks. I'd been deprived of $50 and I should just let it go. And if it was a high risk, I would have let it go. But it wasn't a high risk. It was a low risk. I knew that the appeal would be fairly fast. I knew that it wouldn't take me hardly any effort because I'd already filed a bunch of appeals in the past. I knew that I wouldn't have to pay an attorney because I was going to represent myself. And I knew that I could recover my costs associated with the appeal because they were mandatory under the law. So the reward was low, just 50 bucks, but the risk was also low. I knew I was going to win the appeal and I knew it was going to cost me nothing. So, except for a little bit of time. So I filed it and I won the appeal. So I just want people to know that there are situations in whether it's a normal case or a high conflict child custody case, where you should go to court if it's a low risk, low reward situation. There's other examples that I can bring up, like every time my ex comes to the door, they slam on the door and wake everyone up, and I want to ask the court to have us exchange the child at some medium, some place between homes. That's not a high-risk situation. You're just asking the court to say where you can pick the kids up from. It's not a big deal. It really isn't. There's crazy arguments over the phone, or there's yelling and screaming. I want to ask the court to order us to only use emails from now on. These are low reward because if you lose, whatever. But they're also low cost because, you're just asking for the court to order for you guys to email from now on. These are situations, these are child custody examples. You can use this in other types of cases too. Another example, we'll say out of child custody. In an ordinary case, let's say you won your lawsuit and your opponent isn't paying up and you want to ask for a debtor's exam. Yeah, there's most likely you're not going to find anything useful out at the debtor's exam. Maybe they're broke, they have no money, or maybe they're just going to lie and it's going to be too much of a big deal to prove otherwise. So we're talking low reward, but it's also low risk because under the statutes you're entitled to one. Just by being the judgment creditor, you're entitled to a debtor's exam. So it's low reward, but it's also low risk. It's an example of something you may as well do. I wanted to just bring up another point. Sometimes people will come up and tell me, well, I can't believe you would put up such a fight for something so small. And my counter to that is, I can't believe they would put up such a fight to defend against something that small. You could really look at things like this from both angles. It's not just the person making the request that is unreasonable for making the request. It's also the person resisting the request that's unreasonable for resisting it because it's only 50 bucks. If you're going to point the finger at me for trying so hard to get $50 I'm entitled to because it's just 50 bucks, I'm going to point the finger right back at you and say, I can't believe you're putting up such a huge effort to resist it. So, these really are invalid ways of looking at things, and the court could conceivably look at it one way or the other. But one thing is for sure, the Supreme Court didn't. They didn't tell me anything about how dare me fight so hard for 50 bucks. For all I know, the Supreme Court thought how ridiculous that his ex and the judge put up such a big deal over the request. Reversed and remanded. So anyway, with that, hopefully this video is useful to some people, explains the little known or little the little understood notion that it's okay to ask for something that's small if the risk is also small. So with that, I'll go ahead and end this video and see you guys next time.